We will start with the reading of preamble. Then there'll be a welcome address and introduction by the Honorable the Chief Justice, and then the keynote address, and then vote of thanks. Namaskar, ma'am. Welcome. We're waiting for Honorable the Chief Justice to. Am I audible, ma'am?
Yes.
Yes.
Namaste, madam.
Namaste, brother.
We are extremely sorry. We were about 10 minutes late in the flight landing.
Not at all. Friday.
Apologies. All my brother and sister judges on their behalf sitting in airport lounge.
Yes.
Sorry. Can we, with your permission, can we
Surely,
commence, ma'am?
surely, brother.
Yes.
Namaskar. Very good evening to all. Eminent jurist and Honorable Mrs. Justice B.V. Nagaratna, today is our esteemed guest of honor, Judge Supreme Court of India. Honorable the Chief Justice, High Court of Gujarat, Mr. Justice Arvind Kumar. Other respected judges of High Court of Gujarat assembled together in committee room number 1. Learned Advocate General Shri Kamal Bhai Trivedi. Learned Government Leader Srimati Manisha Ben Shah. Public Prosecutor Mr. Nitesh Bhai Amin. The dignitaries connected through YouTube link to include Honorable the Chief Justice Karnataka High Court, Shri Justice Prasanna B. Warle, other respected judges of Karnataka High Court, members of Registry, learned judicial officers of both the states of Gujarat and Karnataka, members of Bar, law students, ladies and gentlemen. On behalf of Honorable the Chief Justice, High Court of Gujarat, Mr. Justice Arvind Kumar, I welcome all of you in online symposia on the subject, the Supreme Court of India and the basic structure and doctrine to commemorate the Constitutional Day. Happy Samvidhan Divas. The preamble to the Constitution is the pivotal most part of the Constitution. It is the part which defines the objects the Constitution conceives to achieve. In a celebrated case of Keshwanand Bharti versus State of Kerala, Honorable the Apex Court has held that preamble of the Constitution is of extreme importance. It is a part of Constitution and Constitution should be read and interpreted in light of preamble. It is for these reasons any celebration of the Constitutional Day commences with the joint reading of the preamble. With permission of Honorable the Chief Justice, may I request all to have a joint reading of a preamble. May I request Honorable Chief Justice and the esteemed guest of honor to preside the preamble reading.
Yes, Mr. Rao. Madam, with permission,
Surely.
we will read the preamble. Jointly, all of us together, we are reading it.
Yes, yes.
We, the people of India, having solemnly sworn
to constitute
Yeah.
India
into a sovereign
and socialist, secular, democratic republic
and to secure
for
to
all
all
its
citizens
citizens justice,
social,
economic,
and political liberty of
thought, expression, belief, faith,
faith
and
and worship, equality,
equality of
status
and of
of opportunity, and to
promote
promote among them all fraternity, assuring the dignity
of the individual
and the unity and integrity of the nation.
in our Constituent Assembly this 26th day of November 1949, do hereby adopt, enact, and to give ourselves this Constitution.
Thank you, Honorable Ladyship.
With your permission, madam, we will commence once again.
Surely, surely, surely.
Honorable Mrs. Justice B.V. Nagaratna, Judge, Supreme Court of India, and esteemed guest of honor as today's keynote speaker, my esteemed sister Justice Sonia Gokani, Judge, High Court of Gujarat and Executive Chairperson, Gujarat State Legal Services Authority, my esteemed brother Justice A.J. Desai, Judge, High Court of Gujarat and President, Gujarat State Judicial Academy, my esteemed sister and brother judges of High Court of Gujarat who have graced this program by their august presence, my esteemed brother and sister judges of Karnataka High Court, retired judges, all the registrars of the High Court of Gujarat, High Court of Karnataka, Gujarat State, all the officers of Gujarat State Legal Service Authority, Director, Gujarat State Judicial Academy, Sri Kamal Trivedi, Learned Advocate General, Srimati Monisha Lokumar, Learned GP, Mr. Mitesh Amin, Learned Public Prosecutor, all honorable judges of the district judiciary, both Gujarat and Karnataka, law students, all the registrars of the High Court of Gujarat and High Court of Karnataka, and all those who have joined this online program. A very good evening. We just read the heart of our Constitution as a precursor to the celebration of the Constitution Day. This day is very special for our country, which is the largest democracy in the world. Constitution Day, also known as Samvidhan Divas, is celebrated in our country on 26th November every year to commemorate the adoption of the Constitution of India. On 26th November 1949, the Constituent Assembly of India adopted the Constitution of India, which came into force from 26th January 1950. The Ministry of Social Justice and Empowerment on 19th November 2015 notified the decision of the Government of India to celebrate the 26th day of November every year as Constitution Day to promote constitutional values among citizens. We have also been knowing this day as National Law Day. The celebration of the Constitution Day this year has become more special as the distinguished speaker for this program is none other than Honorable Mrs. Justice Bengaluru Venkatramaya Nagaratna, who has imbibed in life the ethos of the Constitution. Born to illustrious father, Honorable Mr. Justice Ingalaguppe Sitaramaya Venkatramaya, who adorned the bench of the Supreme Court of India from 8 March 1979 and then as Chief Justice of India from 19th June 1989 to 17th December 1989. His Lordship, Honorable Mr. Justice E.S. Venkatramaya, was the first judge of Karnataka High Court to become the Chief Justice of India. Now another history for the nation is destined to be created as our distinguished guest of today's celebration, Her Ladyship, Mrs. Justice B.V. Nagaratna, is poised to become the first woman Chief Justice of India. Her Ladyship was born on 30th October 1962, enrolled as an advocate in the year 1987 at Bengaluru and practiced at Bangalore in constitutional law, commercial law, including insurance law, service law, administrative and public law pertaining to land and rent laws, family law, conveyancing and drafting of contracts and agreements, arbitration and conciliation. Her Ladyship also took up pro bono causes, and the city of Bangalore owes to Her Ladyship for the natural beauty left in its lakes, as Her Lady contributed her services as amicus in a matter relating to regeneration of many lakes at Bengaluru. Her Ladyship came to be appointed as an additional judge of the High Court of Karnataka on 18th February 2008 and as permanent judge on 17th February 2010. As we all know, Her Ladyship took oath as Judge of Supreme Court of India on 31st August 2021. Her Ladyship has been kind enough to consider our request of gracing this occasion and to deliver a keynote address on the subject, quote, the Supreme Court of India and the basic structure doctrine, unquote. Before we proceed to listen to invaluable insight of Her Ladyship on this subject, I am tempted to share with you all a couple of examples of the level of commitment of Her Ladyship to constitutional ethos and the extent of compassion and empathy for one and all. A division bench of the High Court comprising of Justice Nagaratna and Justice Hanchate Sanjeev Kumar, in the course of an appeal filed by youth seeking a job with Karnataka Power Transmission Corporation Limited on compassionate grounds following the death of his father in 2014, observed, I quote, "We add that no child is born in this world without a father and a mother. A child has no role to play in his or her birth. Hence, law should recognize the fact that there may be illegitimate parents but no illegitimate children, unquote. During an agitation by lawyers and call of strike by them, when her ladyship insistence and efforts to keep the bench working was opposed to by the members of the bar, her ladyship had made it known to one and all that, I quote, "We cannot be cowed down like this. We have taken the oath of the Constitution," unquote. In an emotional farewell speech delivered by Justice Nagaratna on August 27, 2021, her ladyship, while extolling and inspiring the women of our justice delivery system, had said, I quote, "The message from this leaf in my book, which I want women advocates to take note of, is that with access to the right opportunities, each one of you can achieve your dreams. I therefore urge each one of you to seek out these opportunities, armed with faith in yourself, and stride ahead to achieve all that you want to, and also give back to the society," unquote. For this inspiration and ideology of our ladyship, we are truly fortunate to listen to her ladyship on the eve of August day of Constitution Day of year 2022. I gracefully and gratefully welcome, on behalf of myself and my sister and brother judges of High Court of Gujarat, Her Ladyship Honorable Justice B.V. Nagaratna as the guest of honor and the distinguished keynote speaker for today's celebration. I conclude with the shloka from the Smriti, Yatra Pujyante Narihi Tatra Ramante Devataha. Where women are respected, recognized and honored, Lord remains pleased on that home, society and country. Paying our respects to all the Naris, now I request Honorable Justice Nagaratna to deliver the address. Over to you, Madam.
Yes. Thank you, Chief Justice Arvind Kumar, for your very kind references made to me. Good evening and namaskar to everybody who has joined in. Honorable Chief Justice Sri Arvind Kumar and Honorable Chief Justice Sri Prasanna B. Varale, Chief Justices of Gujarat and Karnataka, Honorable Judges of the High Courts of Gujarat and Karnataka, and former judges of Gujarat who may have joined in, Learned Advocate General for Gujarat and other law officers, Learned Registrars General of the High Courts of Gujarat and Karnataka, Learned Judicial Officers of the States of Gujarat and Karnataka, Learned Directors of the Judicial Academies of Gujarat and Karnataka, Learned Senior Advocates and learned members of the bar from Gujarat and Karnataka who may have joined in, distinguished invitees, learned deans and faculty of law colleges who may have joined in, dear law students, ladies and gentlemen. On the eve of Constitution Day, I extend my greetings and good wishes to each one of you and through you to the entire legal fraternity of our country. I must thank Honorable Mr. Justice Arvind Kumar for initiating this program. Although he mentioned to me that I should speak on 26th of November, as we all know, since we are meeting tomorrow in Delhi to celebrate the Constitution Day, which is actually 26th of November, he nevertheless persuaded me to accept the invitation to virtually address all of you on the eve of Constitution Day, and hence I am thankful to him for this opportunity which has been provided to me. I must also thank Chief Justice Varale for ensuring that all the judicial officers in Karnataka would join in this program, of course subject to the court work not being affected. I also thank all the judicial officers and all invitees and guests who have joined in this program. As we all know, our Constitution represents a consensus, and I would say it is a summit of consensus of India's political history. It was adopted on 26th November 1949, and to commemorate this day, we celebrate what is known as Samvidhan Divas or the Constitution Day or 26th November every year. Our constitution, I would say, manifests the best of our past traditions and has provided a considered response to the needs and aspirations of the contemporary times then and also to the present times. The constitution has a flexibility to handle all requirements in future also. On this day, I would like to pay my humble tribute to the remarkably wise, articulate, and erudite pantheon of persons of outstanding abilities and backgrounds, I must say, who drew up our constitution with meticulous care. We are aware of India's political history, social and cultural diversity, and the socio-economic dreams that the people of our country envisaged on attaining independence. They therefore had helped raise a magnificent shrine of liberty and fraternity based on the import of unity in the mosaic of diversities in our country. I therefore pay tribute to each of the 299 members of the Constituent Assembly and 9 stalwarts, including the great Sri K.M. Munshi, who constituted the Constitution Drafting Committee, and he was also the chairman of the drafting committee, Dr. B.R. Ambedkar. I must also recall in this context Sir B.N. Rao, who was appointed as the constitutional advisor of the Constituent Assembly, who drafted the Constitution in February 1948. As we all know, Sir B.N. Rao toured many countries in order to get the best from various constitutions. Our fundamental rights are based on the American Bill of Rights. Our directive principles are based on the Irish directive principles. Our right to free trade and intercourse in Articles 301 to 304 is based on the Australian Constitution. He therefore drafted a constitution containing initially 315 articles and 13 schedules. And after 2,473 amendments, which out of 7,635 amendments which were tabled, the final draft of the Constitution emerged with 395 articles and 8 schedules. Today, the Constitution has 448 articles in 25 parts and 12 schedules. And our Constitution has been amended 104 times. Before I actually go on to the subject, I would like to also take this occasion to pay my respects to the 15 women members of the Constituent Assembly who spoke for the entire society and who had left an indelible mark having regard to the legal and political social fabric of our country. And hence, I would like to name each one of them. They included the already famous names like Sarojini Naidu and Sucheta Kripalani, Vijayalakshmi Pandit, but other achievers like Durgabai Deshmukh, Hansa Jivraj Mehta, Rajkumari Amrit Kaur, Ammu Swaminathan, Dakshayani Veluyuthan, Kabla Chaudhary, Leela Roy, Purnima Banerjee, Renuka Ray, Malati Chaudhary, Annie Mascarein, and Begum Aizaz Rasool. I guess it is because of these strong women in the Constituent Assembly that we have an article like Article 15.3 of the Constitution, which we all know states that no law would be termed or deemed to be discriminatory if it is in favor of women and children. Thus, our sublime Constitution took over 2 years, 11 months, and 70 days to be drafted. We have just now read the preamble of the Constitution, and therefore I need not read it word by word. But I can say that the preamble is a beacon for all of us, and it reminds us to stay united, strong, and respect the cultural and linguistic diversity in the country. The makers of our Constitution invested great emotion in the preamble, which begins with the words, "We, the people of India." In this context, we in the legal and judicial fraternity must keep in mind that the judiciary with an undisputed integrity is the bedrock of our democracy and rule of law. Even that in every court, at every level, is sacrosanct, whether at the taluka level, district level, or the High Court or the Supreme Court. These institutions have to be maintained and it has to be visibly demonstrated that justice is being dispensed in the best possible manner. Judicial service at all levels is of a constitutional character. And mind you, I'm talking to judicial officers of the district judiciary. Let them not think that the constitution is not meant for them. Dispensing justice is of a constitutional character, and the entire hierarchy of courts is involved in it. Therefore, in my view, every judge at every level must have the pulse of the Indian society in his or her heart and the rule of law in his or her mind while seeking to render justice. On this occasion, I must say that the responsibility of the bar in upholding the independence of the judiciary is of utmost importance. With this preface, let me go to the actual topic, which is the Supreme Court of India, the basic structure. The basic structure doctrine should not be considered as irrelevant or was only relevant in the 1970s and 80s. It is a core of constitutional jurisprudence which has been relevant all through as well as to the present day. It is not restricted just to the higher judiciary, namely the constitutional courts or of the High Court and the Supreme Court. The values in the basic structure doctrine form the core principles of the Constitution, which must guide our thought and decision making at every stage. The object of Indian constitutional development from the time when the Constitution was conceptualized till the present day has been to achieve social and political change while at the same time preserving the Constitution. This is what is called preserving the constitutional identity. It is a paradox, and this paradox has been addressed by the basic structure doctrine, which I will try to elaborate during the course of my talk. But before that, I'd like to recall what Woodrow Wilson, the President of the United States of America, said when he said, and I quote, "A constitution must of necessity be a vehicle of life, that its substance is the thought and habit of the nation, and as such it must grow and develop as the life of the nation changes," unquote. The Parliament's power to amend the Constitution is to be viewed and understood as a power vested in the Parliament to meet the ever-changing demands of the nation. According to Chief Justice Y.V. Chandrachud, it is a safety valve which could be accessed when the need for amendment arises, keeping in mind the requirements of a growing nation. The desire of securing a balance between stability and change is manifested in Article 368, which contains provisions for the amendment of the Constitution. We all know that the basic structure doctrine actually emerged in the now famous Keshavananda Bharati versus the state of Kerala, which has been referred to by Justice Gokani during the course of her introductory words. But it actually lay earlier in the context of the contest between the Supreme Court, that is the judiciary, and the political executive, and as well as the Parliament. We all know that Articles 31A and 31B were introduced in the Parliament for the purpose of abolition of the Zamindari system. The above measures were necessary, according to the Parliament, in order to achieve the goals that were envisaged under the directive principles of state policy. But the Supreme Court rejected that the directive principles of state policy were higher in hierarchy and as opposed to the fundamental rights. In my view, the Supreme Court's early rejection that the directive principles would prevail over the fundamental rights, set the formulation for the basic structure doctrine. In Shankari Prasad Singh Deo versus Union of India, Article 368 was taken up for consideration, and it was then held that the Constitution could be amended without any exception, and even the fundamental rights could be amended. In fact, in Sajjan Singh versus State of Rajasthan, the Supreme Court affirmed the said observation, and that it was not unreasonable to hold that even Part 3 of the Constitution could be amended. But in Sajjan Singh, there is one observation of Justice Mudolkar, who said that did the framers really intend to give permanency to the Constitution, or it could be amended so as to result in a rewriting of the Constitution. This, I must say, is the precursor to what is actually the basic structure doctrine which later emerged. But between Sajjan Singh and Keshavananda Bharati, there was Golaknath versus State of Punjab, wherein it was said that there was no power in the Parliament to alter the Part 3 of the Constitution by any amendment. The Parliament responded to Golaknath by amending Article 368 and enacting Constitutional 24th, 25th and 29th Amendment Acts 1971 so as to abrogate the decision of the Supreme Court in Golaknath. These amendments, as well as the rule of Golaknath, were considered in the famous Keshavananda Bharati case, and 9 judges out of 13 judges, that is the court which heard the said case, ultimately signed a seminal document called the Basic Structure of the Constitution and rendered the same immune to amendment of the Constitution. In my view, the apex court in this case seized a heroic mantle of history in developing a concept which has stood the test of time in India. The court in Keshavananda Bharati, in my view, intellectually repackaged the verdict in Golaknath. The Supreme Court said that Articles 14, 19 and 21 would apply to all constitutional amendments, and therefore these core articles were elevated into the basic structure doctrine, which in turn was placed beyond the pale of constitutional amendment process. Now, what is this basic structure doctrine? In Keshavananda Bharati, many of the judges had their own views on it, and I can recall a few of them. Chief Justice Sikri said that supremacy of the Constitution, republican and democratic form of government, secular character of the Constitution, separation of powers between legislature, executive and judiciary, and federal character of the Constitution form the basic structure. Justice Shelat and Justice Grover believed that the unity and integrity of the nation and the mandate given to the state in the directive principles of the policy are basic features. Justices Hegde and Mukherjee identified their own set of basic features in sovereignty of India, democratic character of the polity, unity of the country as essential features, and they gave a mandate to build a welfare state. Jagan Mohan Reddy J said that the preamble to the Constitution is a basic feature, which translated it to a sovereign democratic republic, and the parliamentary democracy and the 3 organs under the Constitution are also part of the basic feature. I must say that over the years, the basic structure doctrine has proved worthy and is of great respect. In 1975, in the case of Indira Nehru Gandhi versus Raj Narayan, which is popularly called the election case, when the then Prime Minister's election was declared null and void as it was tainted by corruption by the Allahabad High Court, the 39th constitutional amendment was passed to extinguish the illegality. In that case, Justice H.R. Khanna held that the amendment violated the basic structure of the Indian Constitution by stating the democratic setup, rule of law, elections being free and fair in such a setup. Thereafter, in the case of Minerva Mills Limited versus Union of India, Chief Justice Chandrachud stated that the Parliament cannot subvert and destroy the basic structure by destructing the rights under Part 3 of the Constitution in order to achieve the goals of Part 4. He observed that to achieve the majestic ends and ideals encompassed in the directive principles, it was necessary to maintain the purity of means called the fundamental rights. Similarly, in Vaman Rao versus Union of India, Article 31, capital B of the Constitution came up for consideration. Therefore, over the years, the basic structure doctrine has achieved a sanctity and has been invoked frequently by the apex court, although it may have undergone a slight alteration here and there. Now I would go on to see the recognition of judicial review as forming an integral part of the basic structure of the Constitution. Article 371, capital D, was inserted by the 32nd Amendment to the Constitution. In P. Sambamurthy versus State of Andhra Pradesh, the Supreme Court invalidated Clause 5 of Article 371D on the ground that the provision required the orders of administrative tribunals to be confirmed by the relevant state governments. Because the tribunals were set up to adjudicate disputes regarding government services and did not allow high courts appeals, it was held that the failure to make these tribunals as independent as high courts violated the basic structure. Thereafter, we all know that the Administrative Tribunals Act came in 1985 and the same was challenged in SP Sampath Kumar versus Union of India. However, that case ultimately held valid the Act by holding that the Chief Justice of India must have a say in the appointments to be made to the administrative tribunals in various parts of the country. But in Chandrakumar versus Union of India, SP Sampath Kumar was overruled and it was held that Article 323A2D contravened the basic structure as the Parliament could not exclude Article 226 and 227 from being invoked by persons aggrieved by the judgments of the administrative tribunals. The court's decision represented a reassertion of judicial authority over the administrative tribunal system. In the 1990s, SR Bommai versus Union of India is a great decision of the Supreme Court comprising of 9 judges, which brought together sensitive issues in Indian politics and constitutional law, namely the role of state governments relative to the center and on secularism. The majority declared that the basic feature of the Constitution included federalism, social pluralism, secularism, and such features as would delimit the scope of President's discretion under Article 356. Following this decision, proclamations issued under Article 356 have been closely scrutinized for signs of a motive inconsistent with the dictates of the Constitution. What was initially propounded as a basic principle in Keshavananda Bharati therefore underwent successive juristic developments, and in the 9-judge bench decision in I.R. Coelho versus State of Tamil Nadu, the apex court seized the occasion to crystallize the basic structure principle into an axiom or a definite doctrine. The court cemented the doctrine by authoritatively declaring that every amendment to the Constitution, whether it is in the form of an alteration of the terms of any article or an amendment by way of insertion to an act in the 9th schedule, has to be tested by reference to the doctrine of basic structure. Parliamentary democracy being one of the basic structures of the Constitution, which was reiterated in the election case again came up for consideration in the 90s in the case of Kihoto Holohan versus Zakilu, where the constitutionality of the 10th schedule introduced by the Constitution 52nd Amendment Act 1985 was challenged on the ground that it violated the freedom of speech of members of elected assemblies, a basic feature of democracy, and judicial review by curtailing the jurisdiction of the court. The Supreme Court concluded that the preservation of the basic feature of democracy does not and may not require the preservation of free speech interests of elected members in the assembly at all costs to the exclusion of all other concerns. The basic feature doctrine has come up again for consideration in Kuldeep Nair versus Union of India, where parliamentary democracy and multi-party system are said to be inherent to the basic feature. The role of the judiciary in galvanizing our constitutional machinery is characterized by institutional checks and balances, and therefore this basic structure doctrine helps in balancing the various organs of the constitution. In state of Rajasthan versus Union of India, Baig CJ said, and I quote, "But if either the executive or the legislature exceeds the scope of its power, it places itself in the region where the effects of that excess should be capable of removal by the judiciary, which ought to redress the wrong done when properly brought up before it. A scrupulous adherence to this scheme is necessary for the smooth operations of our constitutional mechanism of checks and balances. Thus, from the doctrine of separation of powers flows the concept of independence of judiciary, which is a cherished value by all judges and the entire judiciary, and the rule of law is greatly dependent upon it. In the matter of appointment of judges to the higher judiciary, the basic structure doctrine was again invoked by the Supreme Court after the first judge's case in S.P. Gupta versus Union of India. Namely, in the second judge's case, that is Supreme Court Advocates on Record Association versus Union of India, Scora 1, and later in Scora 2, and thirdly, when the 99th Amendment, Constitutional Amendment came up for consideration in what is known as the NJAC case. The Supreme Court laid down the principle that to maintain the independence of the judiciary, it was necessary to insulate judicial appointments from any interference by the executive. On the strength and edifice of the basic structure doctrine, appointment of judges through a collegium has now become a permanent feature of our Indian Constitution. There have been other cases apart from this, namely Ismail Faruqi versus Union of India at GC Kanango versus State of Orissa, where statutes have been struck down on the basis of the basic structure doctrine. In 2012, a two-judge bench of the Apex Court in Brij Mohan Lal versus Union of India considered a challenge to the establishment of the fast-track courts, which were meant to dispose of long-pending cases in the district judiciary. The bench observed, although as a matter of obiter, and I quote, "Any policy or decision of the government which would undermine or destroy the independence of the judiciary would not only be opposed to public policy, but would also impinge on the basic structure of the Constitution," unquote. In addition, the court remarked that sufficient number of judges have to be appointed at all levels of the judiciary, and particularly in the district judiciary, so that justice is available to the people, and otherwise there would be an undermining of the basic structure of the Constitution. I would say that this is suggestive that governmental inaction could also raise basic structure related concerns. Recently, in Madras Bar Association versus Union of India, a constitution bench of the Supreme Court declared as unconstitutional the National Tax Tribunals Act 2005 as unconstitutional. This is another case where the court tested the validity of an ordinary legislation on the touchstone of the basic structure doctrine. Having gone through all these decisions, in my view, the following aspects would emerge. First, the rationale for limiting the amending power of the Parliament under the basic structure doctrine flows from the principle of separation of powers, invariably sanctified through the written constitution. This principle of separation of powers gives effect to the strategy of checks and balances, which requires that the power of review over the exercise of the amending power of the legislature, usually propped up by the executive, vests in none other but the judiciary. The crux of constitutionalism premised on the principle of separation of powers, thus, is that the power of the Parliament is not unlimited, inasmuch as it is subject to review by the courts on the touchstone of the Constitution. Second, the legitimacy of the doctrine could be traced to the nature of power at Article 368 of the Constitution. The amending power is not truly and essentially a constituent power. The plenary or absolute power which is exercised to make or unmake a constitution. Such a power is only with the Constituent Assembly. The power to amend has therefore limitations and constraints. The power to amend the Constitution is only a division of lawmaking power and not a constituent power by itself. It is indeed a derivative power, a power which is derived from the Constitution. The doctrine is, in my view, one of the greatest contributions of the Supreme Court of India to constitutional jurisprudence and therefore to Indian polity and society. And it is a most befitting tribute to the framers of our Constitution. It is my earnest hope that the doctrine would continue to serve as a normative guidepost to the Supreme Court in its endeavor to perform its role as the guardian of the democracy and the sentinel on the Quay Way. I will not limit it only to the Supreme Court. I would say to all high courts and all other courts which would have a reason to deal with the basic structure doctrine. The interplay of amending powers of the Parliament and the judicial review of the Constitutional Court over such exercise is, according to me, the strength of our Constitution. The synergy of separation is the strength of our Constitution. The values which the Constitution has set out to guard, as framed in the basic structure doctrine, are eternal. We in the legal fraternity in particular and the citizens in general must always respect the constitutional values. They are democracy and the principles of justice, liberty, equality, and fraternity, the ideals enumerated in the preamble of the Constitution. While there is little doubt that humankind in general and our country in particular has made gains in its struggle for justice, liberty, and equality, the progress towards fraternity has not been so rewarding. I must say that the quest towards achieving fraternity must begin with an acknowledgement by all citizens of his or her fundamental duties as enumerated in Article 51A of the Constitution. Although fundamental duties have not been recognized as yet as a basic feature, they are nevertheless a core concept enshrined in the Constitution, and they should serve as lodestars in our quest towards fraternity. Fundamental duties are not to be viewed merely as ethical or moral guideposts to the citizens. They are to be viewed in the context of the broader scheme of fundamental law of the land, which they envisage and seek to promote. The fundamental duties are to be understood as an unexceptionable charter of principles which citizens could usefully absorb and practice. Fraternity even today remains the least understood, least discussed, and perhaps the least practiced of the four pillars of our constitutional morality spelled out in the preamble of India's Constitution. According to me, fraternity would be the key for deepening of our democracy. We, the citizens, have given to ourselves the Constitution of India, and the onus is on us to live earnestly by the letter and spirit of the Constitution. With this earnest hope, I thank each one of you for giving me an opportunity to be heard, and also I conclude by thanking Honorable Chief Justice Arvind Kumar, Honorable Chief Justice Varle, all the honorable judges, all distinguished invitees who have been present online, and everybody else for organizing this lecture. My special thanks to Justice Sonia Gokani for coordinating with me and for ensuring that everything is organized well for this lecture. I also acknowledge the efforts of the Gujarat State Judicial Academy and also the Karnataka State Judicial Academy so as to enable all the judicial officers to witness this evening's event. Once again, I extend my greetings and good wishes to everybody in the legal fraternity and the judicial fraternity on the eve of the Constitution Day, and hope and pray that all of us would work in our work either in the dispensation of justice or for seeking justice for our litigant public. We would ensure that every word, the spirit of the Constitution is always upheld. With these few words, I thank you all for your kind attention. Thank you and namaskar.
Thank you very much, Honorable Ladyship. Indeed, very exhaustive and thought-provoking session. And I am sure all the members of the judicial officers of both the states and all the dignitaries would have got the best of inspirations from the address of Honorable the Ladyship. Only the constitutional scholar and the legal luminary can actually, without making out the session to be a prolix or making it out a laconic on account, can take down the basic facets of the Constitution right since the inception of the making and formation of the Constituent Assembly, salient features of the Constitution, the basic structure doctrine, the independence of the judiciary, the judicial intervention in form of activism, and the most importantly, the precedents. We all, on behalf of the judicial officers of both the states, thank you very much, Honorable the Ladyship. And now I'll request Honorable Ms. Justice Sonia Gokani to express vote of thanks. Thank you.
Thank you.
Namaskar, ma'am, and
Yes.
namaskar to all the dignitaries present here and from outside. It is indeed a matter of honor to be here to express the vote of thanks for the dignitaries, our esteemed guests of honor who has enlightened this august gathering on a very vital and relevant subject today evening, reminding us of the invaluable contribution of the Constitution of India towards the Constitution of India of the Apex Court in guarding the basic structure of the Constitution. Women are said to be the vehicles of change, leaders on the path of progress, and founders of the peace in every society. We have with us today one of those accomplished personality, Honorable Justice Nagaratna, who is also in the role of a guardian and protector of millions, being in the highest court in the land, while working fearlessly with sharp intelligence and with firm conviction in all pursuits, is an inspiration to thousands of young girls entering this profession and a new hope for millions across the country. While also joining her ladyship in paying heartiest tribute to 15 distinguished women of the Constituent Assembly, we also with pride, ma'am, recognize the contribution of yours on the eve of this Constitution Day, who's going to now navigate this nation at a future time as the first woman Chief Justice of India, for having enlightened us how the Apex Court has navigated the wheels of democracy in the light and in the right directions all these years to navigate this nation to an unparalleled heights of excellence in all spheres. A zealous protector of the independence of judiciary when he's with us, let me remember fondly the words of one of our constitutional framers, the member of drafting committee, Shri Kanhaiya Lal Munshi, whom the distinguished speaker has also remembered. He is an acclaimed author and a noted personality of Gujarat who was supporting an amendment number 1967 moved by Dr. Ambedkar, emphasizing, I quote, this constitution, though it has not accepted the doctrine of separation of powers, has maintained the independence of the judiciary to the utmost possible extent. Any fear, therefore, that this independence will not be maintained because we have not accepted the doctrine of separation of power is entirely unfounded one. It must be, and I hope it will be, the duty of House at all times to maintain the independence of the judiciary. It is essential that in a democracy, the judiciary must be there to adjust the difference between citizen and citizen, between state and state, and even between government of India and the state. If that independence is not secured, I'm sure we would soon drift towards totalitarianism. I unquote. Please accept our deep gratitude, respected madam, for being here at our invitation and sparing valuable time. We assure your ladyship that ethos of constitution we shall attempt to imbibe and also shall endeavor to understand the pulse of Indian society while discharging the duty. Our sincere gratitude for my Lord Honorable the Chief Justice for his Lordship's zealous attempt and sincere wish for everyone to celebrate this day in presence of our esteemed guest of honor, being aware of her distinguished qualities and commitment towards the cause. Addressing from the airport lounge is a rare event and which we should all always remember. The gratitude for Honorable Justice Prasanna Varale, the respected Chief Justice of the High Court of Karnataka, for also allowing all the judicial officers of the Karnataka to be present here for this event. The sincere thanks for the learned Advocate General, Shri Kamalbhai Trivedi, learned government pleader and senior advocate, Ms. Manisha Laukumar, learned public prosecutor, Mr. Amin, the learned in charge president and office bearers of Gujarat High Court Bar Association, and also the senior advocates. My sincere thanks to my brother, all esteemed brother and sister judges, and the sister and brother judges at Karnataka. The presence of all judicial officers from across the state and also at the Karnataka, we recognize and we also note that. Our sincere thanks to all respected principal district judges and also at Gujarat and Karnataka, the dear students of the law colleges of GNLU, GLS, Nirma University, and other invitees. Also, the sincere thanks to the registry, without whom we could not have, in fact, conducted. Special thanks goes to Mr. Ukrani, the IT registrar, and the registrar generals of both the states, as well as the directors of the academies of Gujarat, as well as the Karnataka. At the end, I would also quote many speeches of one of the speeches of Sandra O'Connor, the first woman Chief Justice of the USA. She read many a times from an old poem about a man on a pilgrimage who successfully journeys through a canyon, then returns to build a bridge on it. Old man, said a fellow pilgrim near, you are wasting strength with building here. Your journey will end with the ending day. You never again must pass this way. You have crossed the charms, dim and wide. Why will you do the breach at the event side? So others may cross, the old man replied. And that was Sandra Day O'Connor's answer used to be, and that would be the answer of our guest of honor, our esteemed scholar, Honorable Justice Nagaratna, to build the bridge forward for many other women to follow. We also, in our respective fields, will do the same to follow your leadership. Thank you very much, one and all, for today. Thank you.
Thank you so much. Thank you.
May I request all to rise for national anthem? Thank you.
Yeah.
everybody can start the mic and we'll start singing. Jana Gana Mana
अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल वंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभाशिष मागे गाये तव जय गाथा जनगण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे.
Madam, our Registrar General will be there. Just now he has entered your ladyship's house. So
Yes.
permit him to, on our behalf and on behalf of all my esteemed brother and sister judges, to offer a small memento. Our Registrar General is there at your home office. He will be handing over.
Yes, I think he has come. Yes.
Yes.
Please come, sir.
Yes, madam. So now I request our Registrar General,
Please come,
Mr.
sir.
R.K. Desai, to hand over the memento to His Ladyship Honorable Justice B.V. Nagaratna, please.
Why, I didn't expect this. Chief Justice, thank you so much.
No, it's a token of our love and affection. There's
No,
nothing, it's a
the
small token love of.
provided by you is the greatest memento I can have.
No, we can. Thank you, ma'am. Thank you for
Thank you. Thank you so much.
Namaste.
Thank you, everybody.
Namaste, sister.
Once again, happy Constitution Day to all of you. My greetings and good wishes to everybody in the legal community.
Thank you, ma'am. Thank you. Thank you, Sister Rokan. Thank you, Advocate General. Thank you, Monisha, PP, all my brothers and sisters, both at Ahmedabad and at Delhi with me here in the airport lounge. Thank you. Namaste.
Okay, now formally coming session with the permission of Honorable the Chair.
Yes.